Hello everyone. So we were discussing about the mediators panel to be prepared by the district judge. Actually, subsection 10 of section 89A provides that the district judge, in consultation with the president of District Bar Association, prepare a panel of mediators, and the panel must have members either from pleaders, retired judges, or persons known to be excellent in the art of mediation, or such other persons as these district judge thinks fit to be a mediator. But certainly persons holding the office of profit in the service of the Republic are to be excluded from the list of mediations, as they are disqualified to be, and shall inform the list about the list to all the civil courts. So the civil court within his administrative jurisdiction about this panel, that a panel is formed now. If people are not getting mediators or failed to choose the mediators, then from this panel they can easily take. And sometimes if the parties or the pleaders fail to find the mediators, then the concerned court will appoint a mediator from this list, provided that, the section 10, a mediator under this subsection shall not act as a mediator between the parties if he had ever been engaged by either of the parties as a pleader in any suit in the court. The reason is that the question of biasness comes here, and the parties may be tend to be biased to the mediator tend to be biased to the parties in whose favor he worked previously, or he may be revengeful to the parties maybe for some other issues. So it's always, that has to be taken into consideration in order to maintain the best of neutrality in the mediation process. Where dispute or disputes in a suit are settled on compromise under this section, the court shall issue a certificate directing a refund of the court fees paid by the parties in respect of the plain or written statement, and the parties shall be entitled to such refund within 60 days from the issuance of certificate. So once the parties settle through mediation, the court fees shall be returned to them. It says that no appeal, subsection 12, no appeal or revision shall lie against any order or decree passed by the court in pursuance of settlement between the parties under this section. It means the court once passed the decree or order, after the agreement of the parties, there shall be no appeal nor any revision. Why? Because the decision of the court is in compliance or in line with the argument, in line with the decision of the court itself. What does it mean? It means the parties agreed to particular conditionalities, and that's why with their agreement the court passed the order or decree. So they cannot go against their own agreements, and that's why no appeal nor revision is allowed. We will have discussions about appeal and revision in our different classes. Section 89B talks about arbitration. It says that parties to apply to the court for withdrawal of the suit at any stage of the proceedings. So, after the written statement is filed, once the court starts with the proceeding stage, then the parties will withdraw the suit. And the ground of withdrawal is that they want to go to arbitration. The court shall allow the application of withdrawal and permit the withdrawal. The Arbitration Act 2001, here it says the Shalish Ain 2001 will be the applicable in the arbitration process. In case of failure in the arbitration process, the parties shall be entitled to reinstitute the suit, permit it to be withdrawn. So again, the parties are required to be instituted the suit if they fail in arbitration. So The application made before the court under this section shall be considered as an arbitration agreement under section 9 of the Shalish Act. So for doing any kind of arbitration, parties must enter into an arbitration agreement, and that will be decided as an arbitration agreement when the parties give application to the court about going to the arbitration. So that's the whole discipline study. I mean, the Arbitration Act 2001, and the whole issue of arbitration as cannot be covered in this course. Then in 2006, as we said, that at the appellate stage, mediation has been introduced, section 89C. It provides that at the appellate stage, the mediation will be continued if the appeal is from the original decree under order 41, and if it is between the same parties who contested the original suit or the parties who have been substituted for the original contesting parties. So for any order, not decree, I mean, if orders are appealed before the appellate court, there will be no question of mediation. Mediation only applies at the appellate stage when it is original decree. So what could be the modus operandi or procedure for mediation at the appellate stage? It says that the provision of section 89A shall be followed as best as possible. All the procedures of section 89A shall be followed. If something else is there, then that has to be continued. Otherwise, the same process. Now, not much. Section 89D provides a special provision for mediation when the contesting parties to a suit or of an appeal applied for mediation thereof started before the amendment of 2012. This is something related to the limitation issue. It's not of that significance. Okay, and then section 89E provides that the provision of 89A and C about mediation and mediation appeal applied to the such area and comments on such days as the government may by notification in the official gazette fix. So with the government notification, the whole the process will be started. Where any mediation process for settlement of dispute in respect of any suit or appeal is pending under section 89A and C before the Act of 2012, such mediation shall continue. Basically, there was massive developments in 2012 with respect to the mediation issues. I think 89E, 89F, DE, all these provisions were made in 2012. Those related, the applicability about those, as you all know, that amendments are always not retrospective, but it applies once the law is in effect. Then the situations all happening afterwards. A law cannot take into effect to a previous situation. So this is the same rules applies here. Now, if we summarize the whole debate and arguments and contents about mediations, there are several questions. Number one, who can be mediators? What is the procedure of mediation, duration of mediation, how and why, why the question of privacy has been maintained in the mediation process, why the Code of Civil Procedure endorsed or included a non-adversarial proceeding mechanism, which is ADR, mediation, within the civil procedure, although the system, the Code of Civil Procedure is solely based on an adversarial system, and it itself provides the adversarial system. So in spite of being an adversarial system, why it has introduced a consensual mechanism, non-adversarial mechanism within it, that's a very fantastic issue to be discussed, to be thought about. And when the parties fail to find the mediators, what is the procedure then? to initiate the proceedings. And mediation in appeal is not covering all the situations the way it covers in the original stage of the suit in mediation, rather only to original decree, and if the parties remain same or they are substituted by others who are substituting the original parties. One of the important question arises with respect to the Arbitration Act 2001, Shalish Ain 2001, about the applicability of CPC, which says that in case of arbitration, the parties must withdraw from the suit. Now, if a mediation is being conducted by a judge himself and the mediation fails, then he cannot continue to remain there. Rather, it has to be by some other competent court. Competent court means the court which has jurisdiction. Otherwise, I mean, a court which doesn't have jurisdiction cannot, be transferred the suit to that particular court. So, with all these questions, we conclude this part. I hope with the clarity related to this about your questionings and others will further learn or unlearn about the whole system of ADR. But one should and must remember that this is a remarkable change in the CPC. The sole purpose perhaps was to help the court in actually decreasing the number of suits being pending, and it also contributing to the culture of less dependence on the courts, appreciating the parties to know how to solve the disputes with the approach of mediators, not to be adversarial to each other, rather to come up with the objectivity of resolution of disputes through their arguments and discussions, and with the less formal proceedings or settings. They should know how to conclude their arguments. Now, one final question anyone may ask is that what would be the situation, or why the CPC did not include a pre-proceeding mediation? That means if now the setup is that you file a suit and then you go for mediation after the written statement and everything. If the law would be, I mean, the American system, which says that if the law would be brought like this, that before coming to a civil court, one or the parties must try a mandatory mediation process, and if they fail, then they will come to the court. So why our setup did not include that provision? Rather, it included something after the institution of suits and a little more to be completed, and then they go for mediation. So that's all our food for thought. I think we can keep thinking and find our arguments in this regard. So thank you very much.